19th July 2026, and this is Live 3. The EU AI Act, it goes full force in 14 days from now. Can it bind a US company with no EU office? Imagine an artificial intelligence company headquartered in the United States, no office in Paris, no subsidiary in Berlin, no employees in Brussels, but every day, European citizens, professionals, doctors, lawyers, students use its AI system. Its outputs shape decisions inside the European Union. In 14 days on August 2nd, 2026, the European Union's Artificial Intelligence Act enters full application. Tonight's puzzle for each one of you. It is live. Does that law, the most detailed, penalty-backed AI regulation in human history, legally bind this company? Yes? No? Or something the drafters themselves have not yet resolved? Hold that answer. 10 minutes of this presentation and we resolve it. But before I go on, I want your ruling. Comments now. It is a live session, so I will be reading and replying to you. Good evening and welcome to the AI Law Daily here on this channel. This is a live premiere session where I am there available on live chat. I'm your host, a techno-legal analyst and a registered lawyer. I'm Nupur Mitra, and this is your daily 10-minute live conversation at the intersection of artificial intelligence, international law, and the governance collisions, gaps that separate what the law says from what the law does. Over the past 2 evenings, we have built a foundation live. In Live 1, we examined how domestic law, eminent domain, is being mobilized to serve AI infrastructure. In Live 2, we examined the Framework Convention, the world's first legally binding international AI treaty, and discovered that its application to the private sector is optional, subject to state declarations. Tonight, we turn to a different instrument, a regional one that does directly bind the private sector. And we ask the governance question that no one is asking loudly enough as of now. If the global treaty is aspirational and the regional regulation is technical, what sits in the space between them? The European Union's Artificial Intelligence Act Regulation 2024/1689 entered into force on August 1st, 2024. But entering into force and entering into application are distinct legal moments. The Act was designed as a phased instrument. February 2nd, 2025. Prohibitions on certain AI practices took effect. Systems designed to manipulate human behavior subliminally. Social scoring systems. Certain real-time biometric identification systems in public spaces. They were all prohibited. August 2nd, 2025. Rules governing general-purpose AI models, the foundation models, the large language models. Those rules took effect, and in 14 days on August 2nd, 2026, the remainder of the Act enters full application. This is not a future event we are anticipating. It is happening now. Legal scholars Christine, Halim, and Zwitter, writing in the Internet Policy Review in August 2024, described the act as marking, and I quote directly, a significant shift from reactive to proactive AI governance. But they also noted that complex questions remain about the enforceability, democratic legitimacy, and future-proofing of the regulation. Those questions are not resolved by August 2nd, they are activated by it. So let us build the legal architecture precisely here on live. The EU AI Act, it takes what international trade law calls an extraterritorial approach. It does not limit itself to companies physically present in the European Union. Under the Act's scope provisions, it applies to providers, meaning developers of AI systems placed on the EU market, regardless of whether those providers are based in the EU or in a third country. It also applies where an AI system's output is used within the EU, even when the provider sits entirely outside it. On paper, a US-based AI company whose system is used by European citizens falls within the Act's scope. This is the same architecture as the EU's General Data Protection Regulation, which extended European privacy rights to companies worldwide. The AI Act mirrors that ambition. Now, here is where governance theory and enforcement reality diverge. The Act creates a system of national competent authorities, market surveillance authorities, in each EU member state. For general-purpose AI models with systemic risk, the European AI Office established within European Commission holds enforcement authority. Penalties under the Act are substantial. Non-compliance with prohibited AI practices can result in fines of up to 35 million euros or 7% of global annual turnover, whichever is higher. 7% of global annual turnover. For the largest foundation model providers, that figure reaches into the billions. And yet, research published in 2026 by Sostag in a peer-reviewed journal found that foreign companies without EU subsidiaries rarely comply with the Act, with little improvement observed following the introduction of penalties. The enforcement mechanism assumes a point of contact, a legal presence, a registered representative, an entity that a national authority can reach. Where that presence does not exist, enforcement becomes a governance question, not merely a legal one. As Christine and colleagues noted, the Act's success hinges on effective enforcement, fruitful intra-European and international cooperation, and EU's ability to adapt to the rapidly evolving AI landscape. And it brings us directly back to the Framework Convention we discussed yesterday. Legal scholar Cheng-Chi Chang, writing in the University of Illinois Law Review in December 2024, observed that while the Framework Convention and the EU AI Act share common ground, particularly a risk-based approach and emphasis on human rights, they diverge significantly in application. The EU AI Act applies uniformly across public and private sectors. The Framework Convention takes a flexible approach to private actors. As Caglian Aksoy's 2026 analysis in the International Journal of Public Law concluded, the Framework Convention and the EU AI Act shape private law in distinct but complementary ways. Complementary, but not comprehensive, and in that distinction, the gap persists. Before I resolve this, your ruling on the record in the live session. Should a US company with no EU office have to obey the EU AI Act simply because Europeans use its system? Comment 1 for yes, outputs in Europe means European law applies. Comment 2 for no, no presence, no jurisdiction, one word. Let's see the split. So, tonight's puzzle. A US-based AI company, no EU office, its system used daily by European citizens. Does the EU AI Act bind it as of August 2nd, 2026? The answer has 3 layers. First, under the text of the Act, yes, the scope provisions extend to providers whose systems are placed on the EU market or whose outputs are used in the EU. Geographic location of the provider is not a shield. Second, the enforcement mechanism relies on national market surveillance authorities and, for the systemic risk models, the European AI Office. Where a non-EU company has no registered EU representative, enforcement requires international cooperation, mutual recognition frameworks, diplomatic channels, or the company's voluntary compliance. Third, available research indicates that companies without EU subsidiaries rarely comply, with penalties alone proving insufficient to change that pattern. So the legal answer is yes. The governance answer is it depends on enforcement architecture that does not exist fully yet. And here is the deeper insight. The EU AI Act and the Framework Convention, they are not redundant. The Convention speaks to states. The Act speaks to market operators. But between them, for the private AI company not selling into the EU, not subject to a state declaration, simply building systems that affect people globally, neither instrument fully reaches. That is the governance gap that 14 days of enforcement will not close. Tonight's takeaway is this. The EU AI Act is the most technically detailed, penalty-backed AI regulation currently in force anywhere in the world. But regulatory ambition and regulatory reach are not the same instrument. The Brussels effect, the phenomenon by which EU regulation reshapes global corporate behavior through market access leverage, may ultimately prove more effective than formal enforcement. Companies that want European users will comply. Companies that do not seek EU market presence may not. I take this opportunity since it's a Sunday today. You have some time to talk to me. I thought I should connect with you here. It has been a few days, 4 live sessions as yet. The introduction, live 1, live 2, live 3 tonight. And I will be coming with live 4 next Thursday. In the meanwhile, I will be writing on all of these on my Substack and LinkedIn. Please follow that there. And also my website. I keep posting a few things but not everything there. But if you follow me on thoughtleadinnovate.com/newsletter, you will be joining my mailing list. And this way we connect. We connect to an instance where we can sit, chat, talk about all of these issues that matter. That matter to us not just as a scholarly work, but also as individuals of the society, of the humanity. For us, this generation, our previous generation who are still there, and the next generation or the generations to come. So let's engage, let's reshare, let's build our audience together to converse on these important, not only important, but topics that are rarely discussed. Topics that all of us, even the people who are in governance, even the people who are in technology, must know, must converse, must take seriously. So I'm here, and also all of this I'm doing so that I'm able to take all of your comments, suggestions, and write a book maybe someday soon. You could also be a part of that book through your comments, suggestions, or even through active conversation with me through the mailing list. So I would say it would be good, it would be a happy situation for me to be able to reach out to you. A two-way audience, a two-way conversation, and without any platform to depend on. So yes, please do join my mailing list. It is thoughtleadinnovate.com/newsletter. And if you have not subscribed to this channel, the AI Law, Global Security, AI Risks and Liability, please do subscribe. This is not just my channel. It is yours too. See you soon. Let's stay connected. Thank you.